Everyone, this is Derek Ashton with Medcom. Along with me is Nicole Trahan, and we are just getting ready to begin the webinar. I would like to thank you all for joining us this afternoon. We look forward to discussing ERISA compliance for your employee benefit plans. And this presentation is brought to you by Landrum Employer Services. And along with Combined Insurance Services as a co-sponsor. And we at Medcom are pleased to work together with both of their great organizations and bring you this webinar. Nicole and I will co-present today. Nicole is one of our legal consultants here at Medcom. I head up the Health and Welfare Compliance Division, and our job from day to day is to help employers to comply with various legislation and regulations such as ERISA, which will be our special subject for today. Our goal today is to be very informative for you as an employer and to help you understand ERISA better. And along the way, we're hopeful that we can make this an interesting and not a dull presentation, and that's our goal, is for this to be truly informative and helpful to help you find some greater understanding of the law as well as solutions to the challenges that ERISA brings. So with all of that said, we're going to look at today's agenda. And before we do that, I just want to mention that we will have time for question and answer at the end. If you have some questions as we're going along, please feel free to write those in the GoToWebinar interface. That is probably on the right-hand side of your screen. There's a question section, and you can certainly write in any questions that might come up. If there's anything you'd like us to clarify or talk more about, we'd be happy to do that. And we'll save some time for questions there at the end. Also, we are recording the webinar today, and we'll be providing the slides for the webinar, and we'll be providing the recording to Landrum so that they'll be able to make use of that for their various clients. Today's agenda is, first of all, what is ERISA? Next, we'll look at the basics of complying with ERISA and what an employer can do to be compliant. We'll also provide an update on Department of Labor and IRS audits. And then we'll ask the question, how does ERISA relate to benefits that are purchased through what's known as a PEO, or a professional employer organization? And Landrum Employer Services offers benefits that would fit that category. Of course, they do many other things as well, but we want to talk about where your ERISA obligations might lie in relation to those types of benefits. And then finally, we'll ask the question, how are voluntary benefits handled with ERISA? And those voluntary benefits would be, for example, something you might purchase through Aflac or Colonial Life or similar companies. So before we go into all of that, I want to give you a brief introduction to Medcom. You may not be familiar with us, but we've been here in the Jacksonville, Florida area for over 30 years. And we have regional offices in Atlanta, Georgia, as well as the greater New York area. And our home base is here in Jacksonville, Florida. So we are native to Florida, but work with employers in various states. We provide, and have for many years provided, administrative services such as flexible spending accounts, HRA, HSA, dependent care, and similar programs, as well as retiree billing, COBRA, and other direct billing services. Growing out of that emphasis, we have an expanding health and welfare compliance area. As you can see from the screen, we cover a lot of different bases with health and welfare compliance services and are able to help employers in a variety of ways, and this really is our area of expertise. We also have developed a nice line of healthcare reform tools that, as you can imagine, are in very high demand right now, particularly for those employers who have at least 50 full-time employees. And at this point, I'm pleased to introduce Nicole Trahan. Again, Nicole is one of our legal consultants here at Medcom. She attended the Florida Coastal School of Law. She holds the JD, or Juris Doctorate degree, and she's going to discuss why compliance is important and what is ERISA.
Thank you, Derek. As you can see on the screen, this is why compliance with ERISA is important. There are some steep penalties for not complying. Those are all listed right here. We want to avoid that. But we also need to understand what ERISA is so that we know what we're avoiding. ERISA is the Employee Retirement Income Security Act of 1974. And the purpose behind it is to protect the participants in such plans as retirement plans and welfare plans. We will be focusing on the welfare plan portion. ERISA imposes strict fiduciary responsibilities on all plan sponsors. The plan sponsors are the ones that offer the benefits. They're required to distribute summary plan descriptions, which you can see the requirements listed below. And some plan sponsors are required to file annual 5,500 filings. This slide right here shows who is responsible and subject to ERISA. Most private employers are responsible and subject to ERISA, and the employer who has employer-sponsored group health plans, these include fully insured and self-funded plans. And on the next one, they are listed as far as what the plans who are generally subject to ERISA are. On the left-hand side, it shows specifically these plans are generally subject to ERISA. These include the group health and medical coverage, dental plans, vision plans, FSAs, HRAs, all things of that nature that are subject to ERISA. On the right-hand side are the exceptions. These are not subject to ERISA. However, underneath you can see the voluntary benefits that unless they are employer endorsed, they are not subject to ERISA. But if they are employer endorsed, they do become subject to ERISA. And this can be informally done and unintentionally done as well. So that needs to be avoided in order to not be subject to ERISA.
We really want to be sure to emphasize the fact that there are two types of employers that generally are not subject to ERISA. They have an exemption. And the way we remember this is you've probably all heard the phrase that we're not supposed to talk about religion and politics. Well, those are the two areas that are exempted from ERISA. Church groups and governmental entities generally do not have to comply with ERISA. Now, these groups can voluntarily comply with ERISA. They can choose to do that if they would like to, but they do have the option to not be subject to ERISA, and in most cases are not subject and choose not to be. So again, it's governmental plans and church plans. All other employers generally are subject, and so if you are in the car business or the grocery business or the pool cleaning business or any other business that would be a regular private employer or a nonprofit agency. If you're not a church or a governmental entity, you generally will be subject to ERISA. In terms of the basics of ERISA compliance, many employers ask us, I have a cafeteria plan in place, or I participate in a cafeteria plan. Isn't that good enough? And this slide is really designed to show the difference between an ERISA document, which is known as a WRAP plan, and your cafeteria plan, also called sometimes a POP plan. And the main difference is a cafeteria plan is really an IRS based document. It is intended to help employers comply with Section 125 of the tax code. It does not address ERISA so much as it addresses tax code compliance, and it allows employees to pay for benefits on a pre-tax basis. And why would you comply with cafeteria plan rules? Well, that helps you to keep those tax advantages for those employees. And the DOL and IRS are both involved in policing these plans and enforcing compliance. Where on the other side of the page, on the left side, the WRAP plan is really a document that's intended to ensure ERISA compliance. It enables you to set up a single ERISA plan to avoid penalties that you might face under ERISA for not having a compliant plan document and summary plan description, or SPD. And the Department of Labor is the primary enforcement arm for WRAP plans. Now, as the presentation goes on, we will discuss further what a WRAP plan is and how it can help you to comply with ERISA, as well as determining whether, as an employer who's participating in a master plan arrangement with Landrum, you may or may not have some ERISA obligations to look at, and making that determination. We're going to help you with that today. And we're also going to look at what some of the penalties can be for not complying, as well as an update on some of the activity of the Department of Labor and the IRS in their auditing of these types of plans. So again, the basics of ERISA compliance really begin with adopting a WRAP plan. Why is a WRAP plan important? The WRAP plan is important because ERISA mandates that you have a plan document and a summary plan description, or an SPD, and that these documents have specific content included in them. And today, most of the insurance carrier provided documents that you will receive do not meet all of those requirements. So the WRAP document was developed as a way to wrap around the plans to create one ERISA plan and essentially amend all of those insurance carrier documents so that the ERISA language is added into them. And this enables you to comply with ERISA's plan document and summary plan description requirements. WRAP plans, even 5 years ago, were not very popular with smaller employers. Today, we write WRAP plans dozens a week for often very small employers. Just as an example, we spoke with an insurance broker in Central Florida recently. They said they had a 5-employee group, a small dental office that was audited by the Department of Labor. And when the Department of Labor arrived, they said, please show us your plan documents. All they had was insurance carrier certificates, and the auditor said, where is your compliant summary plan description? Do you have a WRAP document? And that insurance broker found themselves very quickly scrambling to find a WRAP document for that very small group. And really, honestly, 5 years ago, even 3 years ago, and possibly more recently than that, a group of 5 employees would not even be considered for such a document because it was so rare that they would be audited. Today we're seeing a lot more activity in this area, and it's really important that employers of all sizes have wrap documents in place. There are some additional benefits. It allows you to, as the employer, set the plan year and the plan number for your ERISA plans. If you are an employer who has to file a Form 5500, that would be an employer generally where you have 100 or more participants on a benefit plan at the beginning of the plan year. Then you would have that Form 5500 requirement. If that's you, it allows you to consolidate your Form 5500 filings. It also lets you add required healthcare reform provisions to your documents. This is another area where many insurance carriers have really stepped back. Eligibility, for example, has become very complicated under the Affordable Care Act. As I'm sure all of you are aware, it is not so easy to define eligibility. Well, one thing we can do with a wrap document is to provide good, solid eligibility language that meets the ACA requirements, which most insurance carriers in the past would provide some information, usually a basic compliant language for that area. Nowadays, many have stopped including any language, and they say simply refer to the employer's plan document. So if you don't have another plan document, then that's referring to nothing. And so you really want to have that wrap plan in place to put those healthcare reform eligibility provisions if you are subject to them. Also, the wrap plan guides plan administration, and it provides some nice legal protections for you as an employer, things like indemnifying the plan administrator. If I was an HR person administering plans for an employer, I would certainly want to have a wrap document in place that indemnifies me to the greatest extent possible from being treated by the law, in other words, sued for some kind of violation. In terms of ERISA compliance, there are really 2 kinds of document. And the wrap document generally will come in 2 pieces. The first is the plan document. The second is the summary plan description. And they have different purposes. The plan document is a legal language document. It's the kind of document that you might read a sentence 4 times and still be wondering what exactly it meant. Where the summary plan description is something ERISA says must be distributed to participants in standard everyday language of the typical participant. And so it's much more of a, we like to say 3rd grade reading level. It's a document that's designed to be very understandable, and it typically will come in a Q&A format. The plan document is all about plan operations. It's for the HR person or the CFO or whoever is handling benefits to refer to, where the summary plan description is to be distributed to explain the plan benefits. And ERISA has obligations for both sides of those types of documents, or both streams of documentation. So a long-term strategy, we're often asked this, if I really want to stay ERISA compliant, what do I need to do over the long haul? Well, first of all, and this is part of what today's presentation is designed to do, you want to identify which employer-sponsored plans are subject to ERISA. You want to find those ERISA subject plans so that you can deal with them in an ERISA way. And then a good step would be to review those plans for compliance. Reviewing plans can be expensive at times, particularly if you have an attorney reviewing documents, as well as reviewing plans. If you, for example, just try to review the plans yourself, you may not know all of the requirements or the ins and outs of what should be in those plan documents. So a lot of employers don't do step 2. It really is a good step to take. It's an important step, but it's often skipped. And so step 3 would apply either way, and that is to adopt an ERISA-compliant wrap document. Whether you've reviewed your plans for compliance or not, the wrap document will cover a lot of issues. And so in other words, what I'm saying is, if you don't go to the expense of reviewing plans, you should still adopt a wrap plan because that will get you some very fast gains. We sometimes refer to it as a 2-minute drill for compliance, and it will quickly bring a new level of compliance to your existing documentation. Then you want to make sure to distribute the SPD. Occasionally, you should check to see if documents need to be amended, and then distribute the Summary of Material Modifications, or the SMM, to participants. And then you'll want to fully restate your documents every 4 to 5 years. Why every 4 to 5 years? Well, as you probably know, regulations continuously change, and it's a good idea to get a restated, brand new document in place to cover any changes that occurred in the meantime. But ERISA also mandates, this is almost an ERISA joke, if you will. It says that you have to distribute the SPD once every 10 years. However, if any changes occurred within the plan, you have to distribute it every 5 years. And so it's almost a joke that you could imagine if a plan had no changes over a course of 10 years, this would be a miracle. So essentially, ERISA says you have to distribute your SPD every 5 years. And that's why it's a good idea to restate the document, get a new SPD, and go ahead and distribute a fully compliant SPD at that point in time. And then, if applicable, take care of your 5,500 requirements. Now, it's really, really important to note that it's the plan sponsor who's responsible for each one of these requirements. The big question that everyone's asking is, will they actually come and audit my plans? You may not be a 5-employee dental office. You may not have ever seen an auditor before, but we're going to give you a quick update on audit activity as it has been reported and publicized, and some statistics about that, and so that you can have a sense of how urgent the case might be. And again, we're not trying to scare anyone, but we want to share the information so that you can make a wise decision as an employer. And with all of that, I'm happy to introduce once again Nicole Trahan.
Thank you. As Derek pointed out, there has been an increase in audit activity. We've seen this based on the ACA coming out with adding 10,000 new auditors, and they have been more than happy to audit not just the large employers anymore, but also the small employers. As a result, the statistics show that 75% of these audits, they discover ERISA violations. And within those 75%, 70% of those ERISA violations result in monetary fines for the employers. Ultimately, we want to avoid that. So that's why this conversation is happening today, so that we can help in avoiding. Some of the things that can trigger a health and welfare audit are listed here. One is an audit, an IRS tax audit done on an employee. That could potentially trigger an audit if they see anything that is questionable. They can trigger an audit for the employer. Some of the other ones are pretty obvious, so the whistleblower and flagrant violations. The Department of Labor also has contracts with all of these listed agencies. So any of these agencies here, if they were to do an audit, it could potentially trigger an audit for the Department of Labor. The scope of the Department of Labor's audit is comprehensive. It includes the things that we know offhand. I mean, we're all familiar with the HIPAA and any violations there, but we might not be so familiar with the WICRA, the Women's Health and Cancer Rights Act, or GINA, the Genetic Information Non-Discrimination Act. But it also covers COBRA and the Affordable Care Act, among others. Again, the penalties are what we want to avoid by being ERISA compliant. The penalties are listed here. Some of the infractions for SPD violations. Just the penalty for a late delivery of a compliant SPD may be as high as $110 per day per plan. These are some of the other various violations that you can see on the screen that are quite steep as well. And we want to be compliant in order to avoid these. And of course, the most serious violations of ERISA may result in civil or criminal penalties and personal liability for plan fiduciaries. Next, we'll cover the ERISA and PEO benefits. In general, compliance responsibilities fall on the PEO-sponsored master plan, and these benefits are typically handled by the PEO. This is for the master plan. Outside of the master plan, any other employer-sponsored plan is under that of the plan sponsor. Therefore, the plan sponsor is the one that becomes responsible at that point. These are some of the important considerations that the employers need to go through. Some questions that they might need to ask is, who is the common law employer? That is, who has the control over the employee? You might want to look to make sure that you know who the plan sponsor is and who bears the fiduciary responsibility. It's also important to know who is responsible to ensure compliance. Other important considerations for the employers are listed here. We don't want to overlook these. An employer who sponsors benefits outside of the master plan is the one who bears the responsibility for compliance with ERISA. It's important that we keep that in mind outside of the master plan. At this point, I'm going to hand it back over to Derek to go over the voluntary benefits and ERISA.
All right, thank you, Nicole. And just to doubly emphasize the point of the last section, it's possible that you as an employer are participating in benefits, master plan benefits that are offered through Landrum. And Landrum is going to be taking care of ERISA responsibilities for those master plan benefits. They would be the plan fiduciary, the plan sponsor for those benefits. They take care of things like 5,500 filings and distributing SPDs and things of this nature. And so one nice benefit to participating in those types of plans is you as the employer can transfer some of that ERISA responsibility to a different plan sponsor, in this case Landrum. And I'd like to mention, just in by way of observation, we've had conversation with the folks at Landrum, and I want to tell you that you have some people there who are really looking out for your best interest. I was just personally very impressed with the level of knowledge and the way that they were taking seriously the ERISA responsibilities. I've personally worked with some other organizations of a similar character who did not take that stance, and so it's really a pleasure for us to partner with Landrum, knowing that they really are taking care of covering the bases in these different areas. But we don't want to overlook the fact that you might not be participating in master plan benefits, or you may have benefits besides the master plan benefits that you're offering to employees. And it's really critical to determine whether or not those are ERISA plans. One area that we think could be a point of exposure for some employers is this area of voluntary benefits. And so we want to take a few minutes and talk about that. And a couple of similar areas would be the areas of wellness plans and what are called employee assistance plans. The rules for these types of plans are similar. And so before we look at the voluntary plans, I want to mention that wellness plans or employee assistance plans, which would typically be a mental health counseling, perhaps, program or a referral to mental health assistance. Those types of plans are subject to ERISA only if they offer a significant medical component. So if the plan actually provides inpatient or outpatient counseling, as an employee assistance plan might, then it will be subject to ERISA. That's considered a medical component. So if it's a significant medical benefit, that will become an ERISA plan. If it is a referral-only plan, for example, employees call a hotline and the hotline refers them to a professional that they can then, on their own volition, contract with, that would not be an ERISA subject plan if it's referral only. So these plans are also sometimes tied in with medical benefits and part of the medical plan. In those cases, they're covered by the ERISA obligations of the medical plan. But it's important to really analyze these things and understand where your plan fits on the grid and whether it fits on the ERISA side or the non-ERISA side. Wellness plans are very similar to the employee assistance counseling type programs. The wellness plan, if it provides a significant medical component, that could include even biometric screenings, that would then be subject to ERISA. So it's really important to keep an eye on whether or not your wellness plan might be subject to ERISA, so that you then distribute a summary plan description, you have a plan document in place, you recognize the fiduciary responsibilities that you as an employer have. If needed, you file a Form 5500 and do all of the other ERISA compliance steps for those benefits. Now, voluntary plans, like the other two I just discussed, are sometimes subject to ERISA and sometimes not. And we need to know when they are and when they're not. And we often say that there are 3 hoops that you as an employer need to jump through if you want these benefits not to be subject to ERISA. The first hoop is that there's no employer contribution. As soon as you as an employer contribute to these benefit plans, you are essentially showing an endorsement for them. You're becoming the plan sponsor for those benefits, and you can no longer claim an ERISA exemption for those benefits. And again, just as a reminder, these voluntary plans are voluntary worksite benefits. Typically, AFLAC or Colonial Life or similar organizations will offer these benefits. So no employer contribution. The second hoop that you need to jump through to treat these as non-ERISA benefits would be that there is no pre-tax contribution made by the employees. As soon as you allow those contributions to flow through your premium-only plan, your cafeteria plan, on a pre-tax basis, you essentially endorse them as an employer. You can allow a post-tax deduction from payroll. There is an exception for what's called payroll practice. So the key thing here is the hoop to jump through to be treating these as non-ERISA benefits would be no pre-tax deduction from salary. And then the third condition is really that you don't endorse these plans either in writing or verbally. And this can get to be a little bit of a gray area. But you want to basically take a hands-off approach. If you want them to be non-ERISA, you need to always direct the employee back to the representative who's selling or providing these benefits, so that they're dealing with, for example, AFLAC with regard to these benefits, and all you have done is made the introduction. You've opened the door, you've allowed the representative to come in and to sell the benefits to your employees, but you've never said, these are benefits that we endorse as an employer, these are benefits we pay for or allow you to buy on a pre-tax basis. You don't list those benefits specifically in your handbook or on any company letterhead document. You really take a hands-off approach. And so sometimes that line can be hard to find, but as a rule of thumb, you want to back away from the line and try not to get too close to it. As my wife tells our kids, if there's a line, think of it like a cliff and stay far back from it, and you're not just going to walk along it. Of course, those are lines of breaking the rules or not, but with these voluntary benefits, you do want to be careful. As a kind of a war story that we're aware of, a very large company based in South Florida. You would recognize the name if I said it, and I won't, but this company, I spoke with someone who handled benefits for them in their HR department recently. She told me that they were stung by the Department of Labor with a big fine because they were allowing the pre-tax voluntary benefits and not treating them as ERISA. So the Department of Labor really does look at this area, and it's something you'll want to keep in mind and be careful about. Now, we're actually doing really well on time, and we've reached just about the end of our presentation. So we want to take some time to answer any questions you might have, and I'm going to go ahead and pull up the questions and see if we have any. And of course, our question to you today is, are your ducks in a row? It looks like we do have at least one question here. And Nicole and I will tackle these. The first question is, can we get a print of these slides? We will be sending out a copy of the slides. So that within the next week you should get a copy of these slides in follow-up to the presentation today. Okay, second question was similar, and we will be sending this out to the email address that you registered with. All right, and great question came in a few minutes ago. Are the plans that we have through Landrum ERISA-Compliant? And I want to repeat something I mentioned earlier. We have really enjoyed our association with Landrum, and I have seen a lot of different benefits offered through organizations of this type. We've done compliance for what are called PEO organizations in the past. It can get pretty complicated from that side of things. But I have yet to actually work directly with one of these organizations that is as serious and on top of things as Landrum. I have been incredibly impressed. Obviously, without or final comments that you'd like to add?
I don't have any final comments other than as far as plans that are through Landrum and whether or not they're ERISA compliant.
That way, if an auditor did arrive and knock on your door or send you that love letter that they like to send, by the way, it has a 6-page data request attached to those love letters they send to employers. In fact, I wish we had one here for an exhibit to show you, but we're often sent those from employers, and they're not nice letters. They don't say thank you for all you're doing. They don't say, we understand you have challenges and we've made this difficult for you. They say, we're investigating your plan, and if you don't send us the documents, we will subpoena them. So they're not nice, and the Department of Labor does have broad powers to enforce ERISA and other laws. So long story short, you want the wrap document to be on top of the stack of documents. And if you have even one plan that is not covered by Landrum in terms of master plans, you really want to make sure that you've got that plan compliant. The nice thing about the wrap is it can wrap around one plan, or it can wrap around 10 plans or 100. It's a very versatile tool. We call it a power tool in terms of legal documents, and it will do a lot for you. This is an area that we at Medcom have extensive experience. We'd love to help employers in this area, and please feel free to ask your contacts at Landrum or Combined Insurance Services for assistance if you're interested in looking at a wrap document as a protective measure for you as an employer. Looks like we do have one other question as I'm rambling on here. So it says, are plans such as long-term and short-term disability are fully paid by the employers required to meet ERISA compliance? The answer is absolutely yes. Long-term disability, short-term disability are generally ERISA required benefits. And particularly if they're fully paid by the employer, that's construed as an endorsement. Now, if they're fully paid by the employee, I will say that we've seen short-term disability plans that are purely voluntary, so that is possible for that benefit to escape ERISA. But as this question is worded, is it fully paid by the employer? Again, that payment by the employer for the benefit is construed as an endorsement. And just if we may, I'd like to jump back to the slide where we show which benefits are subject to ERISA and which ones aren't. So I'm going to just jump back there real quickly so that you can review this again. And this will be in the slides when we send them to you. But as you can see on the left-hand side, we do include disability plans. They are generally subject to ERISA. So at this point, we will go ahead and recheck the questions just to ensure that there are no more. It looks like there are no more at this point. We want to thank you all for joining us today. It's really been a pleasure and a privilege to be with you and spend this time together discussing this important topic. We appreciate your attention, and we hope this has been really, really helpful for you as an employer. And we hope you have a great rest of the week, and thanks again for being with us.